we're used to that.
Fantastic. How are you? It's called I Can't Get In for a Haircut, so it's all in style.
Hey, how much? Well, we had to go under the weather. You know how well you all look up.
Yeah. And they of course, we did enjoy
I saw you in chairman, I was excited. I saw your name and it's I counted.
Michael? Oh, Patrick, you got a little wet this morning. Oh. Morning, sir. Doing okay for a Wednesday?
How you doing, Jim? Patrick?
See. I'm going to take a hard look at it. Always a favor. Wonderful. How are
Well, let me know if you need anything while you're up here.
Both of them are all of them. Yeah.
I didn't be guilty.
Plus, they were the normal, that's my business, that's my house. Hey! Normally,
How many do we have left?
Including this 517, you get
7,100, so he lost 30.
we just have 17.
Well, because.
Pretty good chance.
How are you doing? We're doing good. We're going to next 30. You're pulling the 30. So the 30, that includes 700. You had a perfect storm. So Eric's people were happy. They said, well, they said, I felt we don't have to. Probably last people are down in very low vacation. And at least action on both. The Democrats were okay. Part of that time session.
Who's our fearless leader? Here we've got our fearless leader. Great. How are you? Except. My county's supposed to. And it's one of the. But that's part without neither excuse or justification to look at it's permissive, but they know. And it is only with deliberate willful knowing. Because when you say, having social So I'm going to say
If there's already a no.
then so just as long as there's no note, everything else is fine. Have we called roll yet? One more person.
You say we need but
Jericho is just in the hallway. Did you say here?
at his office.
I can text her.
He was, he came in.
Let me walk over and see if I can get it. Not over just to I'm gonna go grab somebody. Anybody running this one? Based on what, is that the one vote?
Good morning and welcome. This is the Senate Committee on General Laws, Technology, Subcommittee number 1, and thank you all for coming. Please call the roll.
Senator Black?
Here.
Senator Deesep?
Here.
Senator Donovan?
Here.
Senator Sturtevant? Here. Senator Servo? Senator McVeigh? Senator Vogel? Senator Lodge?
Here.
Get the floor, Madam Chair.
Thank you. We will go ahead and get started with the sign-up sheet. Delegate Hodges.
Right here. Good morning, Madam Chair. Thank you. Committee. Let me make sure I have the right bill here. House Bill 2178. Fairly straightforward. And what this does, it extends the current FOIA exemption to proprietary information related to invoices or transactions with charitable gaming organizations submitted by a manufacturer to the Virginia Department of Agriculture and Consumer Services. Currently, suppliers have this FOIA exemption, same information, this is just moving it over to the manufacturers to be consistent. Fairly self-explanatory.
Any questions?
Get into more detail if you need to.
Any questions from the
Madam
board?
Chair.
I don't entirely understand why do we set a special provision for charitable gaming supplies? I don't quite understand why we're severing those out from FOIA.
It's specifically the electronic and mechanical equipment of it, Madam Chair. It's specifically the electronic and mechanical equipment of it.
Currently, the testing on this equipment is, the testing and that information is submitted to the Virginia Department of Agriculture and Consumer Services. And during that testing, there's proprietary information that's in there. So this is just extending it to the manufacturers as well.
So is it the information about how they, Madam Chairman, how they calculate the winnings, or?
It deals with the transaction part and their invoices and transactions. It's my understanding. I have some folks that actually have quite a bit more expertise in this. If you don't mind yielding my time to Mr. Oakey.
Madam Chairman, Bud Oakey with representing Virginia Charitable Gaming Council. We requested this bill. I think staff can go to the broader scope of the testing, but the Commonwealth, to protect citizens who are playing these games, put all of these games, whether it's electronic or not, through a very sophisticated testing to assure the accuracy of it. In that, and you've got on the electronic equipment software driving the process, you have mechanical pieces, all of it has to be wide open to the testing facilities. In the prior, the code protected from FOIA the intellectual property of the suppliers, but that extension did not necessarily go to the manufacturers and the software developers of the electronic equipment. Here we're just adding that in because that is the intellectual capital that makes the game and the business that is developed. That's what protects them. That's their piece of the pie. So we're just merely extending to that to assure that software code, that the dynamics of how the machines operate, that the invoicing, the billing, everything that it does where the consumer is involved stays there in the testing lab and does not become public for competitors in the industry to have access to.
Any other questions from the board? Anyone here in opposition to House Bill 2178?
Move the report. Second.
It's been moved and seconded that House Bill 2178 be reported. All in favor, please say aye.
Aye.
Any opposed?
And I for Diane.
Okay, thank you.
Thank you. Have a great day.
Delegate Massey.
Thank you, Madam Chairwoman. House Bill 1971. As you may remember, I sort of led the House efforts 2 years ago on the 3 sexual assault bills. And as a part of that, we exempted the SARTs, the Sexual Assault Response Team, from FOIA and their meetings from the open meeting laws. Subsequent to that, the Commonwealth's attorneys came to me and said, hey, we would like to also have exempt from those same two, from FOIA and from the open meeting laws, our multidisciplinary child abuse teams. So the bill just exempts multidisciplinary child abuse teams from FOIA and from the open meeting laws, like we do sexual assault response teams. That's all the bill does. And it was at the request of the Commonwealth's attorneys. I don't know if anybody, yes.
Good morning.
Questions to Delegate? Anyone here in opposition to House Bill 1971?
Move the report. Second.
It's been moved and seconded that House Bill 1971 be reported. All in favor, please say aye. Aye. Anyone opposed?
Thank you, Madam Chairman.
Delegate Fogarty.
Thank you, Madam Chairman. House Bill 1876.
Are you Robert?
Information Act. Basically, it would exclude from disclosure the library records of minors. We've done this in the public school libraries, and now this is a follow-up in no one can have any identifying information on anybody under 18 years old that goes to the patrons of the library.
Any questions to the delegate?
But as I understand, then the parents are able to access this information.
That's correct.
Okay.
Parents, guardians, and non-custodial parents, same as the public schools.
Mhm.
Anyone here to speak in opposition to House Bill 1876?
Move to report.
Second.
Okay, it's been moved and seconded that House Bill 18. Do you have a question?
I do. I don't mean to derail the process at all, just a question in terms of the circumstances where we have, for instance, a parent that is, say, in a bad separation case or something, because it says non-custodial parent, and if the kid is, researching information or has looked up an alternate address or where they're living or some other travel plans associated with that, would that put them in a negative posture at all? Because I think the schools have a framework that know who has the parent rights, whereas I don't know libraries would be put in the same posture.
Right, and that was discussed in the committee, but there is no way for the public library to know. So I would imagine when a parent signs up with their child to get the library card, then at that point they would give the library that notation. But it did come up, and the public schools do have information
Right, they do.
that the public libraries don't. But what we may want to make sure that if we don't have this bill, that any stranger could have that information. Right now, a stranger can go to the library and request information on your child's records and what they've checked out, what their interests are. So what this bill would do would
Okay,
eliminate.
so it's the non-custodials that covers it, or is there still gaps? There's some exclusion, so would any, is Maria, do you?
Madam Chairman, Maria Everett with the FOIA Council. The way this exemption works without the bill is that what is protected under FOIA is the name of the library patron coupled with what they're looking at, what they're borrowing. With this bill, what it does is allow you would never get a name, the contact information. So if somebody FOIA'd the library I want everybody who has a library card, they're gonna have to be a way to segregate the under 18. But to answer Senator McPike's question, there is language elsewhere about if your parental rights have been terminated, we could add that part, but as the delegate said, the public library is not gonna particularly know that.
I mean, is there a fix that they're not permanent, or, just a question.
I don't know how the library would figure out how to do it anyway.
Yeah, I just don't know.
So without like some crazy process and a ton of cost.
It seems like it would make it so cumbersome to try to administer. And I don't know that it hurts to have the non-custodial parent unless it's someone who has had their parental rights removed for good cause.
But the name would not be revealed. The non-custodial parent obviously would know that child's identity.
Right, that's sort of the nexus of the problem where we have abduction cases and other things that are generated, and their parents get pretty crafty and creepy, in custody cases and other things, and that's why I just was thinking about how do you prevent, because if a kid's going to that library, a public library every day, how do you prevent them from knowing travel plans, knowing other things where kids Google, and if you, this, as I understand it, would be contained information, not only check out the other information that they're using, borrowing within the library system. I don't know if there's a way to close that at all. I'd be concerned about it, but.
I think it was thoroughly vetted in FOIA, and it's been through 2 years now, and there was no way to close that gap because of the public libraries not having that information that is given by the parent to the school systems. So what we're trying to do is bring in the net as close as we possibly can as keeping your child's and my child's records away from any strangers. But as far as a non-custodial parent, if they would have it, they would know the child's identity, which they know anyway, because they're the parent.
Yeah, that's true, they would know all about the kid anyway.
But I
This just
think,
says what books and
Madam
stuff
Chair,
they
the
use.
exemption would already protect if even a troublesome situation domestically, what is protected now is the name of the patron and the information. So that would stay protected, so the most a parent could get would be just contact information, because what's already exempt, this exemption limits it to just information about patrons. But what's already exempt is tying the patron to what they're looking at or checking out is exempt. So it doesn't give special rights, I don't think, to the parent in that context. It only gives a right to the parent to the address information.
I don't think there's easy fix to it.
Yeah, used to identify the library patron under 18 years of age. So, I mean, they'll already know that, but they can't look necessarily the way the exemption is structured to what they're looking at on the computer or checking out or doing any of that. That's what the exclusion originally and stays that way. So it's two classes, kind of.
Some level of discomfort. I think it sounds like you struggled with it as well in terms of unfortunately access to a potential non-custodial parent that's also a potential harmful or bad actor that is excluded from access and is not excluded, because these are the exclusions, so not excluded from accessing public orders. I find with schools, because schools have a framework to already sort of understand who has parental and custodial rights on it. I don't know if anybody is also tracking on the issue.
Madam Chair, if a parent's rights are terminated, they would not fall under the category of non-custodial parent, right? So perhaps,
There's still pending custody case. There's lots, I mean, you've probably seen as well, as a school board member, different policy issues that have come up. I don't know. I'm trying to not to stay down the train. Respectfully.
We had a motion.
move report.
Second.
It's been moved and seconded that House Bill 1876 be reported. All in favor, please say aye.
Aye.
All opposed?
I'll put a no and hopefully change it to a yes, and I'll do some follow-up.
Since it's not unanimous, I think.
Yes. And so was
Nominate was a yes as well.
I guess that would be you.
All right. Final last? Oh, good.
We'll save the best for last. This is House Bill 1734. This is a FOIA bill having to do with Virginia Parole Board. This was vetted through the FOIA Council last year. What we're doing here is, under current law, there are two exceptions for FOIA on the parole board. One is records concerning finances, and the other is a monthly list of decisions. This adds a modest third exception to include guidance documents. The code defines, or the Administrative Process Act defines guidance documents as information or guidance of general applicability. This also went through, the governor had a commission on parole review and endorsed this concept as well. When we talk about different things that would be applicable to guidance documents, and again, it's very general in its application, policies of parole, geriatric release, revocation, and any future changes, any risk assessment tools that the parole board may come up with would all fall under this exception.
Any questions for the developer?
What's the policy reason for?
Well, I mean, I think under all FOIA, I mean, when you talk about parole board, I mean, first is transparency, number one, for FOIA. But secondly, when you talk about people's rights and liberties, and this is probably the most important aspect of what the parole board deals with. And so when you put those two together, those are really the two policy arguments of why this is so important. I mean, people's rights to be free, their liberties, that's
Madam Chair. I guess something that makes me a little uneasy is that the case law dealing with parole, there is no right to parole. It's you know, it's something that's given, but there's no right to it at all. And it makes me a little uneasy as there are shifts, you know, towards, you know, a little bit more liberal or a little bit more conservative on the approach used, that would have to be made public by either somebody liberalizing or somebody, you know, tightening.
Yeah, Senator, if I may, I think you might be reading too much into it. This is really general applicability, and so it's giving general policies that the parole board discusses, guidance documents that they use for, you know, what criteria do they look for, not individually, but what criteria do they look for geriatric release? What is the risk assessment? What is the data say out there that whether someone, not any individual, but someone is more likely to reoffend or anything like that. The parole board currently does a lot of this already. But in the past, we've known that they have not been so forthcoming and put it on their website and make it a public document. So this just, again, it doesn't get into any individual situation or anything like that. So if your concern is maybe, to your point, liberalizing this, I don't think that we're even close to coming in that direction. It's really of general applicability for these policies. They have them, and most of them are already posted on their website. But this just enshrines in the law under FOIA to add this third exception, so to make sure that it's always the case.
I guess my concern would be that it would provide an area that might be fertile for additional litigation. You know, did they act within the precise parameters of this and so forth? Whereas, as a general proposition, they can grant parole for any reason or for no reason whatsoever. That's, you know, it's plenary authority within the parole board once they've met parole eligibility. They have to do that, but then there's just plenary authority at that point, and I don't know. It's just a little vague uneasiness about.
Yeah, no, I understand. I don't believe it would open up the doors for any of that. I think you could still, the parole board still makes its decisions, as they always have made those decisions. But this just gives a little bit more information to the public on how that goes.
Are there other questions to Delegate Hope on House Bill 17? Is there anyone in the audience in opposition to House Bill 1734? We have a motion.
One question, Madam Chair. Does the parole board have a position
No.
one way or the other?
I've worked with them on this language throughout the years. So.
Move report. Second.
It's been moved and seconded that House Bill 1734 be reported. All in favor, please say aye.
Aye.
Those opposed?
Put him down his name.
Thank you, Madam Chair.
Sir, no, thank you.
Thank you.
Thank you. Then we have one.
I've never heard from Delegate Morris.
We got one.
So we'll just take the last one to the full committee without a recommendation.
Yeah, that's kind of controversial.
So, we're done. Thank you all.
Thank you.
Good one.
Good morning.
Yeah, I make one for Marion.
Hey.
Hey, Phil.
We struggled with that too, and we were concerned about
Yeah.
Are they contentious?
Unlike school, you know, they have all that information.
Well, I think with, a lot of it's we say it's open unless, you know, like the custodial parent. I mean, just, you know, address that issue that says, I don't want this released, you know, sort of like scholastic records where you check the box that says, I don't want this released. Then that gets to, because then they'll know, but yes, it's what they'll have to determine whether you the custodial, you know, I mean, that encumbers the process. And that's- So right now in FOIA, you could get, everybody has a library card, but you can't get everybody has a library card tied to the materials. And then this just says everybody has a library card under the age of 18, you're not gonna get that either.
Can I use a practical example?
Yeah.
I don't know how the boy counts I work for. I have a 9-year-old, and she has a library card. If you go to Chesterfield Library right now and ask for everybody's card, you're gonna find my 9-year-old. And it's, they have to release it right now. This would say, don't release her name. That's all it does.
But the issue is
And
more.
well, as far as tied to materials, as the parent, all I'm really gonna find out is that she has a card of whether it's current, where it's registered.
Yeah, because this is separate from her
Yeah,
materials,
it's not
this
gonna,
is just, you
they
can't
can
get a
still
list.
withhold what she checked in.
But they're excluded from the provision though, so it is materials. It is anything that is.
Well, no, but it only
data
excludes
records.
from clause 2, not clause 1.
Yeah, because it says one,
Or-
both patron and materials, or just any, what she's trying to protect
Clause
is,
two.
I want the list of materials.
Okay, I got you.
You have to
So we're gonna
separate
clause two.
emancipated versus non-emancipated, but your issue is more of, you know, somebody caught in the middle of that, and I don't know, they wouldn't be able to get the materials. Well, I mean, it's discretionary, they could. And so the opt-out is one option, because I know with scholastic records, we put that in play that says, we're talking, maybe a certified legal guardian parent, unless such parent's rights have been terminated by a court. And again, who's gonna know that? But if you put the opt-out provision, then it's open unless the custodial parent, says don't release it, then you, that kind of goes a little bit toward protecting the custody problem, instead of you're just a parent.
Yeah, exactly.
That's
And
why
we just add
that exemption stayed like that. for a long time.
transportation projects approved by the city.
Trying to figure that out.
Transportation
That part.
court.
Okay.
And, you know, you look at it in terms of scholastic records,